I am Dr. Gurjeet Singh from Guru Gobind Singh Indraprasth University, and today's topic of discussion is electronic contract, a very important part of cyber law. In fact, we need to talk about electronic contract because every other day we are entering into contract whenever we are being part of cyberspace or whenever we are opening an internet account or email account. Therefore, we need to understand the legal implications of various kind of activities we do in the form of contract in cyberspace. Prima facie, there are a few objectives of this module. The most important objective is to introduce various kinds of contract, then to talk about unilateral model law of contract, and to compare it with Indian Contract Act and Information Technology Act 2000. Then to talk about the e-signature, which is very important part of electronic contract, and discuss some emerging issues or crucial issues of online contract, in particular the cross-border issues of electronic contract. To start with, we can say that in 1995 onward, internet becomes very important, and it was made available to the public for wider use. Seeing the potential effect of this internet in e-commerce, at United Nations level a committee was formed, and they drafted model law of e-commerce in 1996. Prima facie, there were three important objectives of model law of e-commerce. The first one was to facilitate commerce through electronic mode of communication. The second one was to provide some kind of uniformity to e-commerce. And the last one was to recognize the validity of e-commerce. With these three important objectives, this model law of e-commerce was created. Now it has three important prima facie principles which has been incorporated in fact every other state legislation whosoever has adopted this model law of e-commerce. The three important principles are non-discrimination on the ground that transactions are in electronic means. So the first one is non-discrimination. Second, technological neutrality, which requires that that the rule should be neutral for any future development. And the last one is functional equivalent, which lays down the criteria in which electronic communication will consider equivalent to paper-based communication. Based on this three important principles, the overall model law of e-commerce was created. In fact, you can see the reflection of all this principle in every other article of model law of e-commerce. To great extent, the same principle has been incorporated in Information Technology Act in India. Now, one thing has to be remember that model law of e-commerce is not a convention, but it's a model draft. So therefore, there is no ratification of this convention. So member states are free to adopt this model law of e-commerce according to their suitability. And so in India, we have adopted this model of e-commerce in Information Technology Act 2000. To start with, let's talk about different type of e-contract. More often there are four different kind of e-contract which we more often being part of, and they are widely known in the business circle. The first one is electronic data interchange, then click wrap contract, shrink wrap contract, and email contract. Let's start with electronic data interchange. Now this is the most, we can say this is the oldest form of contract in between a business to business form of transaction, whereby a standard business code or message has been created by the business house, whereby they recognize and give validity to different kind of agreement relating to different kind of transactions. So some of the examples are like purchase order, invoices, shipping notice, export import information, carriers to carrier, waybills, etc. Now this form of contract were very much applicable and used, in fact, before the introduction of internet or cyberspace. and so they are still relevant even though the internet is there and there are it has introduced various different kind of contract. Now the second mode of contract which is widely used in online contract is click wrap contract. We have witnessed to this kind of contract many of the time, and it is absolutely a different kind of contract if you compare it with the traditional mode of contract. In fact, this click wrap contract is derived from the shrink wrap agreements, which is there in when you purchase, go to the market and purchase CD, then you will find some kind of terms and conditions of license are mentioned in the CDs, and before operating or before opening the CD, you have to scrap that particular paper or the cover page of the CD, and once you do it, then it is presumed that you are agreed to all terms and conditions of the CD. So that is the shrink wrap contract. Now the same concept has been introduced in online contract, and it is known as click wrap contract. In this contract, what happens when you download a particular software or game on your computer, you will find some kind of terms and conditions, some kind of box as shown in the slides. This kind of box will come and they will say before being party to or before downloading it, you have to accept the terms and conditions of the software. If you accept, then only this software will be downloaded on your computer, otherwise not. I mean, there is no bargaining point. You can't do any kind of bargaining. You simply have to either accept, take it, or leave it. Therefore, this kind of contract are known as one-sided contract also. It doesn't give any kind of scope for the other person to do any kind of bargaining relating to any consideration or anything relating to the product. So they will only be downloaded to your software once you agree and you click on the I agree button of the software. Now, since it is different from traditional mode of contract, so at one point of time or at the initial point of time, we can say there was some kind of doubt relating to the validity of contract. But in fact, in various cases decided in US court, it has been held that this kind of contract are very much valid and legal, and there are some cases which I have already mentioned like Hotmail, CompuServe, Netscape. These are some of the contract of this type. Then the other contract is a browse wrap contract. Again, this is derived from shrink wrap contract, and to some extent they are similar to click wrap contract, except there is no requirement for express consent like in the case of click wrap contract, because in click wrap contract, till the time you don't express your consent, the contract is not complete. But in case of browse wrap contract, though the box may open up or the terms and conditions of download of the software or any other thing on your desktop may be conditional, but it is not subjected to giving the consent. So even if you don't give the consent and you access the software, many of the time the software will be downloaded on your computer. Now, one of the term or mostly the terms and conditions of this browse wrap contracts are like, by using this site, you agree to these terms of use. If you do not agree to these terms, you may not use this site. So it is presumed that once you are using this particular website or downloading according to the terms and conditions, so you are agreeing to the browse wrap contract. Even if you have not gone through personally to see each and every provision, howsoever reasonable, unreasonable they are, but because you are clicking and downloading it, so it may be presumed that you are very much part of the contract. Now, of course, at the beginning also, again, when this kind of contract started, there was some kind of confusion about the legal validity of this browse wrap contract. At the initial time, there was some kind of uncertainty relating to the validity of browse wrap contract. But US court has come out with various judgment where they have shown they are inconsistent on the validity of browser app contract, depending on how the terms and conditions of browser app contract has been reflected or has been shown on the website itself. Even in the case of browser app contract, since it is very much similar to click wrap contract, the other party doesn't have any kind of bargaining power, and whatever terms and conditions, even if they are reasonable, unreasonable, they have to be accepted by the other party. And relating to the validity of this kind of agreements and the contract, there are a number of cases which supports the validity of it. In fact, there are no cases even in the case of click wrap and browser app contract at this point of time in India. So we don't have any cases, but we accept that the grounds or the basis of which they have been accepted in US, most probably they will be accepted in India also. The last one contact is the type of contact is email contact. Now this is very much similar to the traditional type of contract which are being formed in Indian Contract Act, or which are being covered under Indian Contract Act. It is in the traditional form because here there are two different parties and they have plenty of time to decide about the terms and conditions, the terms of services, the kind of different conditions. They can always decide, they can bargain about the product, the quality of the thing they can ascertain, and many other things. So therefore to great extent it is very much similar to the Indian contract or the traditional contract being covered under the Indian Contract Act. The only difference is why they have been classified in Information Technology Act and electronic contract, because the contract is being generated through electronic means and they are happening online, and therefore they are being part of online contract. So here also there are two important parties in particular. The first one is addressee. It has been defined in IT Act also. So addressee is the person who receives the electronic record as intended by the addressee, and then the originator who sends, generate, store or transmit any electronic message or cause any electronic message to be sent, generated, stored or transmitted to any other person. So they are just like offerer and offeree, and the formation of contract is made in between them when the electronic message is communicated from originator to addressee, and then acceptance is being conveyed by addressee to the originator. Now the most important part is to be seen in this traditional online contract is that in this kind of contract they don't fall in the category of non-instances, they fall in the category of non-instantious services, for the simple reason once a offer has been or acceptance has been sent by the parties to the other party by electronic mode, then till the time that electronic communication is not being viewed, till that time the contract is not complete, and therefore they fall in the category of non-instantious services. Now from Indian perspective, one important case is there which has been decided in 2014, that is Trimax International FZE Limited Dubai versus Vedanta Aluminium Limited, where it has been held that this kind of contract are very much valid under the Indian Contract Act. Of course, Information Technology Act doesn't say, in fact the model law of e-commerce also doesn't focus or say anything that the whole contract has to be created on online contract, then only it can be classified as email contract. It may happen that a partial contract can happen in the traditional mode and partial contract may happen in the electronic mode, then also it can be covered under the electronic contract.